Custody evaluations and transparency. Custody evaluations often influence where children live and how often they see each parent. Judges rely on them. Attorneys build strategy around them. Parents structure their cases in response to them. But I have yet to encounter a case where the interviews that form the backbone of these evaluations are all recorded. I've never encountered a case where the interviews of the children are recorded. Never. Not once. Lord knows I've tried to have them recorded, but I've never succeeded yet, and I don't know of any other custody evaluation where the interviews of the children conducted by the evaluator were recorded. Instead, the court receives a narrative summary from the evaluator about the alleged interview and its contents. And so the foundational interviews remain unreviewable in their original form. That is not a minor procedural detail. It is an evidentiary design choice, and a poor one at that. If a custody evaluation materially shapes a decision under Utah's best interest factors and the opinion rests on unrecorded interviews, what exactly is being tested in cross-examination? Memory? Notes? Professional credibility? Without an authenticated contemporaneous verbatim record of the interview itself, there is no independent way to assess tone, context, question structure, or whether leading language influenced responses. Experts may rely on otherwise inadmissible information, true, but when the summary becomes the functional equivalent of testimony, safeguards matter. This is not an attack on evaluators. It is a structural critique. Even well-intentioned professionals must operate within robust, reliable systems. A system that does not require preservation of foundational interviews shields methodology from meaningful scrutiny. It limits cross-examination, constrains appellate review, and concentrates narrative control in a second-hand source. Transparency protects everyone. It protects children from misquotation, evaluators from accusations of distortion, and courts from relying on unreviewable narratives, and parents from structural disadvantage. If custody evaluations are influential enough to shape outcomes, they warrant corresponding safeguards. No evidence should carry decisive weight while remaining insulated from decisive scrutiny. The question is not whether evaluators are trying to do their best. The question is whether the structure matches the weight placed upon it. That is a conversation worth having openly.